The problem is the way that the decision was overwritten to talk about the influence of the budget and what OFM is referenced in the majority opinion. Again, it is not the province of the court to determine whether the legislature is spending the money wisely or foolishly. If it's foolish, you vote the legislature out of office, you vote new people in. The courts are in business to interpret the law and not to go on at length about their particular view of budgetary priorities. And that's my heartburn with the SEIU versus Gregoire case. In Anderson versus King County, the Defense of Marriage Act case, again, I'm not in the social engineering business, but I've read the state constitution many times and the federal constitution. It doesn't talk about marriage anywhere. Article 1, Section 7 of our state constitution, as my opponent likes to say, enhances our individual citizens' right to privacy well beyond that which is protected in the federal constitution. We have greater rights in many respects, greater constitutional rights under our state constitution than we do under the federal constitution. So whether you believe that the issue of gay marriage is a subject for referendum or for legislation, both of which have occurred on the subject, it's one thing to make the decision based upon the law and the facts. It's another thing to moralize in the decision about, well, gay parents can't properly bring up children, and there's this data that says there's a higher incidence of dissolution of these quasi-marital partnerships between gay and lesbian people than otherwise. I mean, if you have the right to privacy in your personal affairs, then you have the right to be free from governmental intrusion on some of the decisions you make. So it is not so much the decision, but the overriding of the decision to include references to how religion should involve itself in our laws, and we should be opposed to gay marriage because it violates the precepts of many religions. To equate a gay partnership with polygamy, which was also done in the majority opinion, I thought, was simply unnecessarily vituperative. And there's no place in that, in judicial opinions, for that kind of moralizing. Interpret the law as you will, based upon what it says, and that's okay with me. The reason there are lots of lawyers is because there's lots of different ideas about what the law says. But it doesn't, it doesn't serve anybody's purpose to use pejorative language and demeaning language in opinions, and that's my problem with Anderson versus King County. You can read it for yourself. The majority in that case, by the way, characterized Justice Johnson's concurring opinion as unnecessarily prolonging the length of the case, the decision itself.
So how do you define marriage?
Well, I'm concerned that under the judicial canons, this case may come around before the Supreme Court again. There's obviously a federal decision out of federal court in Massachusetts that found the Federal Defense of Marriage Act unconstitutional. I suspect that that's going to wind its way, I'm certain that it will wind its way through the federal appellate system, and that may end up with a return if there's some sort of unconstitutional finding of the Defense of Marriage Act by the Washington State Supreme or the U.S. Supreme Court. Then the Washington State Supreme Court may again be faced with the issue. So, I mean, I've tried to answer the question as best I can, but the rules about judicial campaigning and judicial conduct prohibit you from commenting about how you might rule on any particular matter that's likely to come before the court.
So you can't tell me how you define marriage?
Well, marriage.
Because I'm asking Justice Johnson answer that same question as far as how do you define marriage?
Well, the statutory definition of marriage in Washington is in the statute, and you get a license, and it's between two consenting. I think you have to be 18 years of age or older, and it's
Doesn't mention sex. Doesn't mention the sex. Male and
no,
female?
I think it does. I think it does mention sex.
So then, if it does mention the sex, and Justice Johnson says he's ruling or he's writing his opinion based upon the definition, why do you see that where is the contradiction?
Well, I'm not sure what it says specifically about sex.
You just told me.
Well, no.
That's all I was asking you.
Right. I think that it's a contract. At the heart of it, marriage is a contract. I've had two cases before the Washington State Supreme Court where the partners were unmarried. One a Vietnamese couple, there's a terrible car crash, and ultimately it turns out that those partners were married in the sense of they had a Buddhist ceremony, and they lived together as man and wife for 14 years. They had a couple of kids, one of whom also perished in this car crash. But they didn't have a marriage license. So are they entitled to be treated as a married couple? And the court ultimately, Justice Bridge wrote the majority in that case, said yes, they were in terms of property division. So in terms of how you treat people that are cohabiting without the benefit of a marriage contract, I think that the legislature has addressed that and in fact has addressed that on numerous occasions. In terms of the actual marriage contract, I think that as far as the government is concerned, you are not able to marry unless you are of heterosexual, a man and a woman. As far as what your rights are, your property rights and other rights that you have to claim benefits for health care and the rest, that is a matter of legislation, which kind of is dependent upon the circumstances. But it is legislatively determined. So as long as the statute says you have to be a man and a woman in order to marry, then that's the way the law should be applied. I certainly go along with that.
If I could piggyback a question on Matt's earlier, he asked, how do people pick? A lot of people, I think, pick based on endorsements. What endorsements do both of you have? Who has given their blessings to you?
The endorsement list grows as time goes on. I've been endorsed by a number of labor unions, the WEA, the SEIU. As I said, the list continues to grow. I've been endorsed by a lot of organizations. Planned Parenthood of Western Washington has endorsed my candidacy. FUSE, which is an amalgam of organizations, many of whom are conservation voters. Have been endorsed by many legal professionals, lots of people in the area of public education and in the conservation movement. I expect that within the week I'll receive the Washington Conservation Voters endorsement.
Have any bar associations rated you?
The bar associations, I have only been rated for the Superior Court. I've not been rated for the Supreme Court, although we have had interviews that are now pending with the Washington Association of Prosecuting Attorneys, the King County Bar Association. There are organizations that are in
and
the
your
process.
rating for Superior Court was what?
It depends on anywhere from well qualified to exceptionally well qualified. And I interviewed with the Asian Bar Association, Hispanic Bar Association, the Lauren Miller, which is the African American Bar Association, the Gay Lesbian Bar.
These are only interviews, not endorsements.
No, those are interviews. These are endorsements. Now I'm back to your Superior Court
okay.
question.
Justice.
I don't know. As I'm sitting here, Farm Bureau, I remember when they did that, but I have not been out working the endorsement. I do remember because one of our interviews with another newspaper, he mentioned his favorite justice on the court was Tom Chambers, who used to be president of the trial lawyers. And I'll tell you what I told him then, and Tom Chambers has endorsed me. A number of the other justices have endorsed me. So I really have not been out beating the bushes for endorsements. I'll go to any place that I can talk to the people, more likely, and through you to the people is what I'm trying to do.
Your opponent has said that you've collected over $1 million from special interests like the insurance industry. Has the insurance industry endorsed you?
No, they have not, and I don't know where he gets these numbers because I read the PDCs to digress a moment. I did not and do not know who is giving and how much. When we've had public meetings and I know there will be a collection done, I get up and leave the place. But I don't remember. I don't remember. There never was $1 million from any group, nor in any election.
You say on your website that he's collected over $1 million from special interest, including the insurance industries.
If you look at the PDC reports from 2002, which was a failed election, and 2004 when he was elected, you could find that special interest organizations or their surrogates were contributing money in chunks of $30,000 or $40,000 or $50,000. Now that, since '06, that's a thing of the past, and I certainly agree with Justice Johnson on that point. There has been some restraint that has been brought finally by statute to the kinds of campaign contributions you can collect from any given individual. But it's in the PDC.
So how do you feel about the WEA and labor unions? Don't you see that those as being very influential and powerful entities in the state?
Well, the WEA, you know, I've worked at Bates for 7 years on their board. I enjoy the support of a variety of educational organizations, including the teachers that work for the WEA.